So as most of you know, yesterday, February 16th, was the third annual rally in Tallahassee, a day when consumer groups and activists from all across the state of Florida traveled to our state's capital to meet with legislators and to talk about changes that are being proposed in Florida's foreclosure laws. Now, this year was even bigger than ever before. We had groups from all across the state that were part of this. PICO, a group of religious leaders from the central part of Florida, members of Occupy from all across the state, attorneys from all across the state, just good old-fashioned consumers who were up there in Tallahassee, many of them on buses all night long, wanting to be actively engaged in part of the democratic process. Special thanks go out to Peter Tickton, attorney on the East Coast, Dan Rock here in Pasco County, Mark Stopa, John Coates, Chris Forrest, Greg Clark, John Page. I'm sure I'm forgetting a few, but frankly, all of these attorneys supporting the community, supporting good democracy, and showing the very best of what it is to be a lawyer in the practice of law. They set a great example for our lawyers in the consumer mind, and I'm grateful to them. I know all the citizens that participated were grateful as well. Let's start for a minute by analyzing who are the stakeholders in the foreclosure process and in foreclosure litigation. It's very important to understand these dynamics. Number one, we obviously have the property owner. Number two, we have a bank. Number three, in many cases, we have a homeowners association, a condo association. Number four, we have a title company. And number five, we have the court system. It's important that we understand who those parties are so that we understand the legal relationship and the interplay between all of them. Let's focus importantly on the homeowner and the bank and that relationship between the homeowner and the bank. You see, property rights in this country are among the oldest, most well-developed, and fully explored areas in our law. They frankly started at the very beginning of this country. It's one of the things that made this nation unique. And so our system of property ownership is deeply rooted in all of our law, our Constitution, in fact, common law, and in statutory law all across this country. Now, when you own a piece of property, that ownership of property is one of the preeminent fundamental core rights in this country. It has some of the strongest protections, legal protections and otherwise, of all other rights that we have in this nation. That's an important fact to keep in mind because it's a key factor in American exceptionalism in our legal system and in our whole government politics. The fact of the matter is that when you own a property, you get a title to that property, and that gives you a set of rights that are key and core and have been respected from the beginning of this country. Now, in Florida, we are what's called a lien theory state. And that means that the mortgage that I'm holding here in my hand is a lien against the property. The homeowner owns the property free and clear, subject to the title, long recognized rights. If a lender comes along and wants to put a mortgage on top of that, he puts that mortgage document on top of that ownership right of the homeowner. Now, key to this relationship here is that both parties understand who each other are, and both parties understand the rights that they have within these documents, which frankly have been around for hundreds of years. Now, here's where the analysis becomes important, and that is when the parties sign the mortgage that are at interest in this case, and when the parties sign the title that was at interest in any particular foreclosure case, they understood exactly what the legal relationships are. This lender here didn't make this loan without understanding precisely and specifically what the relationships are within these contracts. And the fundamental point that I'm going to get to, frankly, and it overarches all of this, is a concept known as ex post facto or impairment of contracts. And that is, in this country, we cannot have legislation which retroactively impairs the rights of contracts between two parties. And the problem with the legislation that's currently pending is that it does impair the rights of these contracts, the parties to these contracts. Now, let me say, I've tried desperately to be a participant in this process in a cooperative and productive way. I don't just want to throw roadblocks up, but as I left last night from Tallahassee, I really tried to look at all of these stakeholders here to understand the relationships and to try and see whether there was some language in this bill that could be written that would answer the needs of all the stakeholders. But again, as to the relationship between the bank and the certificate holder, the title owner of the property, that relationship is established by the mortgage particularly and the note. The typical mortgage in Florida is about 16 pages long, the Fannie Freddie approved mortgage. And the terms and conditions in there, much of it written in ancient language, is because it has been around that long. But there are specific legal consequences to the language within these documents which cannot be changed by legislation after the fact. Now, if they want to change legislation prospectively and go back and change mortgage documents, they can do that. But that's not the problem that we face here in this state right now. So that's the examination of the relationship between the title holder and the mortgage lender. The most important thing to understand is that when that title owner gave that mortgage lender a right to put a lien against his property, that title owner gave it knowing that there were certain rights inherent in that contract and in our legal process. And those rights cannot be impacted or diminished by subsequent legislation. Now, let's talk about another relationship here, and frankly, it's probably the most important one that's driving the current foreclosure reform legislation, and that's the relationship between the homeowners association, the condo association, and the homeowner, title owner, and the bank there. The fact of the matter is that likewise, when the homeowners association decided to let the property owner purchase the property, the documents that govern that relationship between the title owner and the homeowners association were a contract between those two parties. Before that title owner could take title to the property, he was on notice and had to read the Declaration of Covenants of Condominium that are official records. And so these two documents here are contracts between the homeowner and the condominium association. Likewise, before the bank can put a loan against that property, that mortgage holder is on notice of the condo association documents that have an OR book and page number. So now we have a three-party relationship here. We have the homeowner right here, certificate or the title. We have the bank right here that has their mortgage, and we have the homeowners association that has their declaration of covenants. All three of these parties have contracts that interplay one another. And the fact of the matter is that deeply rooted in our law in this state and others are the concepts of priority and title law. But the fact of the matter is that the homeowners association has the primary rights, and everything that is on title beyond that are subservient and inferior to the rights of the property owner. Now, in some ways, the Declaration of Covenants is sort of parallel, because as a condition of having the title to the property, you agree and consent to the Declaration of Covenants if you're in a community that has Declaration of Covenants. But here's where relationship really becomes problematic in terms of foreclosure reform. And that's the relationship between the bank and the homeowners association. You see, when the bank recorded this mortgage, that bank was aware of this document here, the Declaration of Covenants. The bank understood that there was a certain priority between the Declaration of Covenants and its mortgage, and frankly, the understanding, the explicit legal understanding, is that the Declaration of Covenants and the condominium documents are subservient and inferior to the condo or the mortgage document, which is superior in the chain of title to it, except for the very clearly and specifically defined priority given to condominium association liens in Florida statute. The point is this. The current legislation seeks to change the relationship of these parties and to give the homeowners association a right not found in these contracts or in this relationship to set this bank's loan and foreclosure for sale. Again, as I approach this from all different angles, I am taking a bank's position now and looking at how they might respond to this legislation. I think a bank would look at legislation which says this inferior lien holder, inferior to my bank lien, attempting to set my case for sale is ex post facto. It's an impairment of the contract that I signed when we, the bank and the condo association, were on notice of what the rights and responsibilities were at the beginning of this relationship. So you see, I think even if legislation passes in its current form, I think any legislation which would circumvent or change this relationship of the homeowners association to the mortgage would be impermissible in a constitutional sense, and frankly subject to a pretty quick appellate challenge. And as much as I hate to agree with the banks, I think the banks would probably come out on top in that argument. Now, one other relationship here, and that's found within the legislation dealing with forcing a homeowner to make payments into to the bank as a condition of having their day in court. Now, I find this is a due process problem for a couple reasons. Let's start with one thing. The fundamental concept is that any homeowner, any resident of the state of Florida has a right to have access to a court proceeding. You are not required to, as I say, pay to play. In fact, that's what happens in this legislation. The amended order to show cause proceedings would force the homeowner to pay for their day in court. Now, this is not a relationship, or this is not a requirement that was contained within this original document. When the homeowner gave the bank a right to have a mortgage against their property, they did not contemplate or understand that one of the things they would be giving to the bank was the right to set this order to show cause, and frankly, and most importantly, they did not understand that what they were doing was making their title right subservient to the right of the mortgage, and that they would somehow be compelled or forced to come into court and pay the bank as a right to exercise their due process and have their case heard in court. That's a fundamental problem that exists in the legislation, and it's one of the problems that I think will make it subject to challenge from a homeowner's perspective. There's another aspect of it from the homeowner's perspective that comes to play, and again, this is one of the other major forces that are behind the legislation at this point in time, and that's the subject, Section 6, at line 236, entitled Finality of a Mortgage Foreclosure Judgment. I think this, too, is one of the major drivers behind this legislation at this point in time. It's the title industry coming in here and saying that there's such a mess out there with the 300-some-odd thousand cases that are pending across the state of Florida and the title problems that exist for the tens of thousands of other ones that have rushed through improperly over the last couple of years. What this particular Section 6 attempts to do is to eliminate the right of a homeowner to ever come back and challenge to get that property back if it were taken from them improperly. Now, let's again go back to a fundamental understanding of American property rights. From the beginning, literally, one of the foundations of this country was the respect of basic property rights, and importantly, real property rights, the home or land around us. Now, again, it's deeply rooted in our Constitution that land, farmland, that homestead, that house you grew up in, that vacation property has a lake on it, is unique, particular, and specific. It cannot be replaced with any amount of money, no matter what it is. And so, this particular piece of legislation right here in this section, which attempts to convert a claim that a homeowner may make to get that property back into a claim for money damages, violates those fundamental notions of American property rights. I find that is repugnant from a constitutional perspective, and I think that would be subject to challenge. The fact of the matter is that we understand what the problem is. We understand why this is there. The foreclosure mills, in their rush and the banks in the industry, in their rush to push through these foreclosures, engaged in what could best be described as sloppy procedures in the far end of the spectrum, grossly irregular, potentially fraudulent procedures, and the title companies are afraid that this conduct is going to lead to challenges and claims on title. That absolutely is the case. Now, there should be claims on title. There should be challenges to that. I, as an attorney, and you as consumers, when we are aggrieved by the wrongful conduct of a party, have a right to go in front of a court and petition to have our grievances redressed in a court of law. What this section attempts to do is to say that even though there have been aggrievements and even though there have been abuses of process, you no longer have the right to fully explore and protect your rights. Now, this is an absolutely disturbing part of the legislation, and it's one that has to be understood for what it is. We cannot allow people to have their rights stripped away, particularly when it's acknowledged at the front end that I would have rights under this mortgage to challenge it if something goes wrong. When I gave this mortgage, I gave only a lien. I never intended that if something went wrong, the bank engaged in improper conduct. Through their improper conduct, I could lose forever that family homestead that has been in my family for hundreds of years. Now, an important other point to mention about this section, because of the absolute nature of it, even if a day after the foreclosure sale, I found out that the plaintiff who had obtained the foreclosure judgment had engaged in the most grossly abusive criminal fraud, and it was absolutely documented. Let's say that they absolutely forged documents, that they had no right whatsoever to foreclose. They forged documents, and they used those documents as part of the court process to get that property back. Or they engaged in other grossly improper practice before the court of law. What this section says is no matter how bad the violation, no matter how egregious it is, you can never go before the court and get that family homestead back. At best, you are limited to a claim of recovery for damages against a plaintiff who is going to be long gone. That's another aspect of this is, the shadow plaintiffs that we see out there. We understand that they are not particularly well capitalized, and the shifting plaintiffs, it isn't really the banks that own these things. They're just acting as service persons and in straw entities for the actual parties that do own these things. So let's talk about what the real solution to all of this is. Well, the fact of the matter is that we have to bang on the mantra of the Republican ideology and Republican philosophy, and that is we have to let the market solve these problems. Let's talk about the stakeholders here that are really pushing this legislation, the homeowners association, condo associations. Myself and all good consumer attorneys and frankly consumers understand that you have to pay your homeowners associations, your condo association dues. And from what I hear from my friends on the condo side, that problem has largely been addressed. The consumers get that message. They're making their payments to our condo associations. That's not as big a problem as it used to be. The real problem here is the vacant and abandoned houses that the homeowner has left, and the condo association is stuck with a piece of property here with no homeowner living in it, nobody defending, nobody doing anything, and they need fees to be coming in. Well, what the market is doing is the condo associations are going in and they are obtaining certificate of title to these properties by filing their own foreclosure judgments, which they've been able to do since the beginning of time. So if they file a foreclosure judgment, they're able to get it expedited, they're able to get title to that property back very quickly. Now the homeowners association owns that property. They set the property up for a rent, and they get somebody in there and they start getting income in. Now, the way to solve this problem, the conflict between the HOAs and the banks that won't set these sales, is to increase and encourage that relationship, that long-standing ability of the homeowners associations to set these sales, take title to the property, get homeowners and renters into these properties, start renting them out, get the AC on, condo fees paid, insurance paid, maybe something for taxes as well. Now, to the extent that the banks are not moving this thing forward, and to the extent that the HOAs and condos have to do anything at all to get a homeowner in there and not recover their losses, what should happen is the bank's interest in the property should be reduced to the extent that the HOAs have had to come out of pocket like that. So again, it's the market that will solve that problem, and it's occurring all across the state of Florida. I have a feeling now that this legislation is a couple of months old. This legislation, this push here, doesn't reflect the current market circumstance where the condo associations are doing this and renting out condos and renting out the units quite successfully, frankly, and that many of them are relatively satisfied with the proceedings when their attorneys aggressively pursue these cases. The second thing regarding the title insurance industry and their claims for absolution for the wrongdoing of the title mills and the foreclosure companies. The fact of the matter is that there are going to be claims out there, but the claims are not going to be too explosive. Moreover, all they need to do with the current cases that are clogging up our court system is to make sure that they're done properly. And this can be done with some amount of effort. You're seeing it right now among all the foreclosure mills. They're doing their best to clean up the title problems that give rise to the concern found within there. So again, The fix here is not to change existing law. The fix here is to use the law as it exists and follow the rules as they exist. Had we done that from the beginning, we wouldn't be in nearly the problem that we're in right now. One closing point about our court system. The fact of the matter is, and in my experience, particularly here in the Tampa Bay area, and particularly in Pinellas County, our court system functions incredibly well, very, very efficiently, given the scarce resources that they have to work with. But the fact of the matter is that our courts are able to set the hearings that are necessary, particularly the homeowners associations, on an expedited fashion. And they're able to get things done in the manner that they need to in a relatively efficient basis. This is a mess, the current foreclosure litigation, is no question about it. But what we all have to do is take a deep breath and understand that if we pass legislation resembling its current form, we're going to be buying ourselves a lot more trouble in the long run. The key to this is understanding that we can't change the contract rights as they exist. We all need to go back and use the law as it currently exists in its current fashion to solve the problem before us now. But thank you to all the legislators that are taking this issue very seriously, devoting an incredible amount of time and energy into this, and to seeking out the input and views of all stakeholders. Listen to your constituents. Keep things the way they are. Let's keep Florida moving forward based on the existing laws. Let's not make a problem worse with laws that will complicate things.